Good afternoon, Your Honor. May it please the court. My name is Nick Wuthrich. I'm representing Team 2, and I'm also here today representing my client, the State of Olympus, the respondent in this case. The issue before us today is whether the 2015 Health and Effective Action Law, otherwise known as HEAL, violates the free speech rights of healthcare providers under the First Amendment to the United States Constitution. The State of Olympus respectfully asks this court to affirm the decision made by the United States Court of Appeals for 3 reasons. First, it has been recognized that the government may limit speech if it furthers a legitimate government interest, which in this case HEAL does. Second, the limitation on speech is protected by a valid time and place restriction. Third, Dr. Jeffrey Ho aided and abetted Cassandra Williams in the procurement of alternative medicine. Before respondent reviews the case at bar, I respectfully ask this court if they would like a recitation of the facts. So I'd like to begin, Your Honor, with a little bit of refutation regarding petitioner's case. And I'd like to point out that much of petitioner's case is based upon the doctrine of strict scrutiny. And they began, learned counsel began their time by talking about the Florida bar test. However, the government in this situation does meet the Florida bar test, as I will elucidate further at a later point. But briefly, the government does have a substantial state interest in keeping the public safe. Secondly, the government follows established medical guidelines in recommending the treatment process for leukemia. And third, the regulation is narrowly drawn because the restriction on professional speech is only valid until an individual is removed from society, removed from posing a danger to society, and is placed in quarantine. They secondly brought up that a time, manner, and place restriction does not apply to the government here, but it certainly does. This is because in this case, the government is banning speech, HEAL is banning speech that endangers public health, and when in quarantine, medical professionals can resume and speak about whatever they want, but it is only when there is an individual who has been diagnosed with a potentially fatal infectious disease that medical professionals are prevented from advocating for alternative treatments that will not remove the individual in question from society and protect the remainder of society from contracting this potentially fatal disease.
Where are you getting the notion that it's only, that Section 4 of HEAL is only active, only applies to doctors when patients are not in quarantine? Because looking at Section 4, it doesn't mention that time restriction. It just says they're prohibited, period, from advocating for, referring to, practicing, etc., alternative treatments at any time, in any place, in any manner.
Well, Your Honor, I would agree with you that perhaps that is an example of a little bit of inartful drafting, but I would like to point out that it would be, that it doesn't make sense that the banning of such speech would even be relevant at a time that's not related to an individual who does not have an infectious disease. So a medical professional in the State of Olympus may well make a blog post about the efficacy of a mind-body treatment process, but they should not make that recommendation to an individual who has been diagnosed as contagious and who poses a significant public health threat.
Let's use that hypothetical. Would they really, under Section 4 of HEAL, would they be allowed to write a blog post? It says they're not allowed to practice, advocate for, refer to alternative treatment in any context, official or personal.
Well, Your Honor, I would like to say that HEAL is referring to, in general, the speaking and the doctor-patient relationship between individuals who have been diagnosed with a contagious disease and their doctors. And I'd also like to point out a test that was brought up in Consolidated Edison v. Public Service Commission, where the Supreme Court wrote that this court has recognized the validity of reasonable time, place, manner restrictions that serve a significant governmental interest and leave ample alternative channels for communication. So
what
even if you don't...
What channel did Jeffrey Ho have?
So even if you, Your Honor, don't buy this idea that Mr. Ho could speak about treatment in any other capacity, WB and Cassandra Williams definitely had the ability to learn on their own through such channels as the public library or the internet or out-of-state medical practitioners about other types of treatment other than the quarantine process.
But I don't
So-
think that matters. I mean, the First Amendment suit's being brought by Jeffrey Ho. Whether or not Cassandra Williams could have Googled it doesn't seem like it's important at all. The issue is whether he was being restricted. And that brings us to the question that I still have. I mean, what alternative channels did he have? If the case you just cited requires alternative channels and he doesn't have any, how does that impact him?
Well, Your Honor, respectfully, Consolidated Edison refers to the communication of a certain message, a certain ideological message, because the court doesn't want the state to only have a single message unless there's this massive governmental interest being satisfied. And here's where I bring up WB and Cassandra Williams. They're not only able to find out about quarantine, they're also able to find out about, through alternative channels, they're able to find out about different types of treatment options. So
I
this...
get that, but Consolidated Edison didn't say the audience has to be able to figure it out through alternative channels. It means the speaker has to be able to communicate through alternative channels, right? Is that a correct reading of Edison?
I would disagree with that slightly, Your Honor, because I would say that Consolidated Edison concerned a public utility services expressment of a certain ideological message, which the court said may or may not be objected to by the state board itself. And the question was really whether the customer, in this case receiving an insert in their monthly utility bill, electric bill, has the ability to find out about other types of information. So
isn't that a problematic standard? So let's assume that I'm a dissident, a political dissident, and I want to criticize the government, and I say that the dictator of our government is corrupt, and I am thrown in jail because of that. Is it suddenly okay because the people I was talking to could have Googled it, they had alternative means to reach the same information? Or is it wrong because I didn't have alternative means to communicate it?
Well, Your Honor, I would say that that's an entirely different issue because that pertains to political speech and not professional speech, and I think that is a matter for the court to determine at a different time. I'd like to move on now to respondent's first argument, which is that the state of Olympus is justified in limiting the speech of Dr. Ho because doing so advances a substantial state interest. As I've said, in Consolidated Edison versus Public Service Commission, the Supreme Court established that the state can limit the speech of individuals so long as the government can show the regulation is a precisely drawn means of serving a compelling state interest. HEAL is a statute that exists in order to promote the standardization of practices across the state of Olympus's medical community with regards to infectious diseases and promote public health. The law exists for the purpose of preventing the spread of contagion within Olympus's communities so that the health and well-being of the general public is preserved. HEAL prevents medical practitioners from propounding opinions at odds with the general consensus of the medical community because any so-called alternative treatment option does not remove the contagious individual from the community and thereby endangers public health. As such, the HEAL's legislation's limiting of speech satisfies the court's test because it does serve the compelling state interest, preventing the spread of infectious diseases.
But what if the alternative treatment did involve a quarantine? It would still not be okay under Section 4.
Well, Section 4, Your Honor, refers to the general application of such methods that are like homeopathic or holistic or etc. What Section 4 is ambiguous about, of course, is the quarantine. And the state is arguing on our side that it is the quarantine that is so important to the treatment of the individual because, of course, the fact pattern states that we're not quite exactly sure whether it was the antibiotic treatment process or the mind-body treatment process that helped the individual in question, WB, heal, but the WB was prevented from spreading their contagious disease because they were quarantined, and that is the important part. And Dr. Ho's treatment process did not involve any quarantine process.
So what if Dr. Ho instead said, all right, I have this alternative form of treatment, it involves being quarantined for 60 days. Would that be fine? It seems like Section 4 still wouldn't apply. Like Section 4 would still say he's not allowed to even do that. Is that not an issue? If quarantine is so important to you, isn't Section 4 a problem? Because the alternative treatment could impose a quarantine even higher than the quarantine that was allowed under Section 3.
Well, Your Honor, I would say that I mean, I think it's important to note that, of course, Section 4 doesn't include any statement about quarantine itself, but it's important to just look at the fact pattern in this case. Dr. Ho's treatment did not involve a quarantine. So respectfully, I'd rather not get into what ifs, because we have to work with the facts that we're provided. And in this case, Dr. Ho was dangerously keeping WB in contact with the rest of society. In Florida Bar v. Wentford, Inc., the court considered a similar question. A referral service for law practices was granted by the Florida Bar from soliciting its services to individuals recently involved in an accident. The court ruled that the bar's restriction of commercial speech was permissible because commercial speech may be regulated if the government satisfies a test consisting of 3 related prongs. First, the government must assert a substantial interest in support of its regulation. Second, the government must demonstrate that the regulation on commercial speech directly and materially advances that interest. And third, the regulation must be narrowly drawn. The state of Olympus in this case does satisfy all 3 prongs. First, as I've stated, the government has a substantial interest in preserving the public health. Second, the HEAL Act follows established medical guidelines, as I've said, involving the use of quarantine, so that a dangerous individual is not allowed to remain in contact with society. Third, Section 4 of the HEAL Act is narrowly drawn because, as the state alleges, and as the state argues today in front of you, medical professionals are prevented from advocating for alternative treatment strategies only until the patient is removed from contact with the general public and the patient has the ability to find out about alternative treatment methods through any alternative channels.
Again, where are you getting that?
Well, this is based upon the state's reading of Section 4 of HEAL, Your Honor, so obviously that's a question
Part
to
of
the court.
Section 4, I mean, I'm not seeing the time part, the time restriction.
Well, it seems that this is a contentious issue between us up here right now, Your Honor. And I think that it's just important to, once again, go back to the test established by Consolidated Edison, which is that there's a significant governmental interest and there are ample alternative channels for communication. And I think that now it's important for me to briefly touch on the second argument, which I've spoken about already, but it's that the limitation on speech is protected by a valid time and place restriction, which I've spoken at a lot, but I'd like to say that in Tallahassee Memorial v. Cook, it shows that there are situations where the individual and society are safer when there are regulations in place to guarantee that they are not to be reintroduced to society until they are healthy. The reason for this is that the risk the individual could suffer or impose due to a mental disorder, as was relevant in Tallahassee, or to an infectious disease, as in the case at Barr, is that these serious infectious diseases pose and have the potential to unweave the fabric of society. This threat doesn't last forever, and as such, the restriction does not last forever. And thirdly, the third argument is that Dr. Jeffrey Ho aided and abetted Cassandra Williams in the procurement of alternative medicine because based on the test laid out in Conant v. Walters, he directly profited from advocating for an alternative treatment process which was illegal under the HEAL Act, and he allowed Cassandra Williams to obtain that illegal treatment procedure. So in closing, I'd like to say that the State of Olympus respectfully asks this court to affirm the decision made by the United States Court of Appeals based on the justification of limiting the petitioner's speech to further a substantial government interest during a valid time and place restriction, and Dr. Ho's aiding and abetting of Cassandra Williams in acquiring illegal treatment under HEAL. Thank you.